Breaking news tonight, and this one is not routine, not procedural, and not easily undone. What unfolded over the last 24 hours may mark one of the most consequential confrontations between the executive branch and the federal judiciary in modern American history. In a move that stunned legal experts, rattled Washington, and sent shockwaves through global markets, President Donald Trump's administration has openly refused to comply with a direct federal court order, declaring in unmistakable terms that it will not provide due process protections to hundreds of deported Venezuelan migrants. The refusal was formal, deliberate, and public, and it was filed not quietly, but aggressively in federal court. At the center of the storm is U.S. District Judge James Boasberg, a veteran jurist appointed during the Obama administration, known not as a partisan firebrand, but as a methodical institutionalist who has repeatedly ruled against both Democratic and Republican administrations. This time, however, he has become the most visible obstacle in President Trump's revived immigration enforcement campaign, and the White House has decided that obstacle will no longer be tolerated. The migrants in question, 252 Venezuelan nationals, were deported earlier this year under a rarely used and deeply controversial statute, the Alien Enemies Act of 1798. Revived by the Trump administration as part of its post-2024 election mandate, the law allows the president sweeping authority to remove foreign nationals deemed threats to national security during times of conflict. The administration alleges that those deported were affiliated with violent transnational gangs and posed imminent danger to American communities. Within days of their removal, the migrants were transferred to El Salvador and placed inside the country's most notorious high-security detention facility, the Terrorism Confinement Center, or CCOT. The images alone were enough to ignite international backlash, mass incarceration, razor wire, armed guards, and total isolation. Judge Boasberg intervened shortly afterward, issuing an order requiring the administration to establish a mechanism by which the deported individuals could challenge their removal and designation, arguing that even under expansive executive authority, some baseline due process must exist. It was a narrow ruling on paper, but in practice, it struck at the heart of Trump's enforcement strategy. The administration's response was not compromise. It was defiance. In a Justice Department filing submitted just hours ago, the government flatly rejected the judge's directive, asserting that the court lacks authority to impose procedural requirements on national security deportations conducted under Article 2 powers. The filing argues that once removed under the Alien Enemies Act, the individuals are no longer entitled to U.S. judicial protections, and that no further compliance will be forthcoming. The language was unusually blunt, no hedging, no delay tactics, no promises to negotiate. The message was simple: the executive branch will not obey this order. That decision, according to multiple sources, was finalized during a late-night White House strategy session involving senior advisors, including Stephen Miller and Attorney General Pam Bondi. Those present reportedly framed the moment as a line in the sand, a test of whether unelected judges could continue, in their words, to paralyze a democratically elected president's core mandate. The political calculation is clear. Trump's inner circle believes the 2024 election delivered a sweeping endorsement of aggressive border enforcement, and they argue that endless litigation, injunctions, and procedural demands have hollowed out that mandate for decades. This is not just about immigration policy. This is about power. The refusal to comply has already triggered an emergency response from the federal court. Judge Boasberg has scheduled a high-stakes hearing for next week, one that could include contempt proceedings against administration officials. And unlike symbolic rebukes, contempt carries teeth. If the court escalates, it could impose daily fines, compel testimony under oath, freeze agency actions, or in extreme circumstances, authorize arrest warrants for non-compliant officials. These are not theoretical tools. They exist precisely for moments when court authority is openly challenged. What makes this confrontation so volatile is that both sides appear fully committed and fully aware of the consequences. Within legal circles, the administration's move is being described not as routine pushback, but as a calculated gamble, the kind taken only when confidence in higher courts, particularly the Supreme Court, is exceptionally high. Insiders say this reflects a collapse in deference to lower courts, a shift that signals the administration believes appellate relief is not just possible, but imminent. Silence from Republican leadership on Capitol Hill has only amplified that perception. Gone are the days when party leaders rushed to defend judicial institutions on principle. Instead, many are hedging, waiting to see which way the wind blows. Privately, several GOP senators have described growing panic within judicial advocacy circles, with some distancing themselves from Boasberg's ruling to avoid alienating a voter base increasingly hostile to what it sees as activist courts. Public loyalty to institutional norms is giving way to cautious alignment with Trump's defiance. The legal cascade is already in motion, and once it starts, it doesn't pause. It doesn't wait for talking points. It doesn't care about optics. Federal procedure is built like a staircase. Step on the first one, and the rest follow whether you want them to or not. If Judge Boasberg presses forward and formally demands compliance, the system reacts automatically, not emotionally, not politically, mechanically. A court order triggers obligations. Obligations trigger deadlines. Missed deadlines trigger enforcement. Each phase exists because the one before it failed. That's how federal power asserts itself. Not with a single dramatic strike, but with relentless escalation. The first move is simple: comply or explain. But explanations don't stop clocks. They don't suspend authority. They only buy time, and time is the one resource the system is designed to exhaust. When compliance doesn't come, the court doesn't ask again politely. It issues findings, then warnings, then consequences. And each refusal compounds risk. This is the part most people misunderstand. Defiance isn't static. It doesn't freeze the situation, it accelerates it. One defiant move doesn't just break a rule, it legally obligates the next enforcement step. The system assumes resistance and is built to absorb it. That's why pressure increases geometrically, not linearly. Behind the scenes, the administration knows this. That's why what's happening internally matters just as much as what's happening in court. There is intense coordination underway. Internal critics are being isolated. Dissent is being reframed as disloyalty. Legal teams are preparing emergency appeals that may never be filed, but must be ready at a moment's notice. Communications staff are working in parallel, shaping a narrative meant to harden public opinion before the next legal shoe drops. This isn't improvisation. It's contingency planning. The message they want locked in is simple and repeatable. This is about protecting Americans, not defying judges, not undermining the courts. Protecting Americans. Every memo, every briefing, every public-facing statement is engineered to reinforce that frame. Because once enforcement escalates, perception becomes a secondary battlefield. White House sources suggest they believe resistance from what they describe as rogue judges is weakening. Not legally, yet, but politically. They see public scrutiny shifting. They see fatigue setting in. They see an opportunity to flip the dynamic from defense to offense. That's the inflection point. This is where institutional restraint starts to erode. Where survival instincts take precedence over tradition. Where compliance becomes conditional, and conditions become leverage. In normal circumstances, the executive branch bends before the judiciary. That balance is foundational. But these aren't normal circumstances. When pressure stacks from multiple directions, legal exposure, political vulnerability, internal fracture, the instinct isn't to yield. It's to push back harder, faster, and louder. And that's where risk multiplies. Because courts don't negotiate narratives, they enforce orders. If compliance doesn't happen, the remedies become personal. Contempt findings, sanctions, mandated actions overseen by third parties. Each one strips discretion away and replaces it with obligation. At that stage, control shifts. The administration may believe it's shaping the battlefield, but once enforcement begins, the terrain belongs to the court. Every motion becomes reactive. Every delay shortens the leash. Every public statement is weighed against sworn filings. This is why the word cascade matters. Cascades don't stop halfway. They continue until something gives. Either compliance happens, authority is reasserted, or the conflict escalates into a constitutional confrontation that no one can fully control. What's unfolding now isn't a single legal dispute. It's a stress test of the system itself, a test of how far resistance can go before enforcement overrides politics entirely. And the most dangerous moment in any escalation isn't the first defiant act. It's the moment when everyone involved convinces themselves the next step won't really happen, because that's usually when it does. Expect the rhetoric to intensify. The response is already being scripted, even if the cameras aren't on yet. President Trump is expected to address the issue directly, and when he does, the venue will matter almost as much as the words. A post on Truth Social would signal defiance and immediacy. A primetime statement would signal escalation. Either way, the frame is predictable and deliberate. The judiciary as an unelected obstruction, a deep state barrier standing between the executive and public safety. This isn't legal argument, it's narrative warfare. And that narrative is already moving. Allies are echoing the theme in near real time. Talking points are aligning across media appearances and social platforms, reinforcing the idea that the courts are detached from reality, insulated from consequences, and indifferent to the risks faced by ordinary citizens. The language is sharp, emotional, and intentionally binary. Protectors versus blockers. Action versus paralysis. International voices are being selectively amplified to reinforce that framing. El Salvador's president has praised the deportations as tough but necessary, holding them up as an example of decisive governance in the face of chaos. That praise isn't accidental. It's being used to signal that strong executive action is not only defensible, but globally admired by leaders who prioritize order over process. At the same time, condemnation is being cast as predictable noise. The United Nations and major human rights organizations have denounced the actions as violations of international law, citing due process and treaty obligations. But within the administration's messaging strategy, those critiques aren't threats. They're props. Evidence, in their telling, that global institutions are out of touch with national realities. This is where the conflict widens. Because the consequences don't stop at the edge of Washington. They ripple outward, touching alliances, markets, and the perception of American stability itself. NATO partners are watching closely and nervously. Open conflict between the U.S. executive and judiciary raises uncomfortable questions about reliability. If internal legal authority is being contested in public, what does that mean for commitments abroad? For treaty enforcement? For coordinated action in moments of crisis? Diplomats don't ask these questions on record, but they are asking them. Quiet signals are already moving through diplomatic channels. Requests for clarification, expressions of concern, carefully worded statements emphasizing institutional stability and rule of law. These aren't reprimands, they're early warning flares. Allies don't need certainty to grow uneasy, they just need ambiguity. Markets, as always, reacted faster than governments. Today's movement was sharp and uneven. Border security and defense-linked stocks surged, buoyed by the expectation of increased enforcement spending and expanded executive authority. Investors know how to read political momentum, and they don't wait for court rulings to place bets. But the broader indices dipped, not dramatically, not in panic, but noticeably. Enough to signal discomfort. The word circulating quietly among analysts wasn't recession or inflation. It was paralysis, constitutional paralysis, the fear that prolonged conflict between branches could freeze decision-making, delay budgets, stall appointments, and inject long-term uncertainty into governance. Markets hate many things, but they hate uncertainty most of all. This is the contradiction at the heart of the moment. Short-term winners emerge even as long-term confidence erodes. Volatility becomes opportunity for some and risk for everyone else. And the longer the standoff lasts, the harder it becomes to separate legal dispute from systemic strain. What makes this moment especially volatile is that both sides believe time favors them. The judiciary believes enforcement mechanisms will eventually compel compliance. The executive believes public pressure and political fatigue will weaken resistance. Both assumptions can't be true forever, but they can coexist long enough to do damage. This is no longer just a policy dispute. It's a test of narrative dominance layered on top of a test of constitutional boundaries. Each statement raises the stakes. Each reaction narrows the off-ramps. And once global confidence starts factoring internal conflict into its calculations, the issue stops being domestic altogether. That's when the real costs begin to surface, not in headlines, but in trust. This moment represents a deeper fracture. Former allies within the judiciary are now viewed as adversaries. Institutional defenders are quietly stepping back, sensing what may be coming next. Many insiders believe this confrontation is heading toward a historic inflection point, a Supreme Court decision that could finally curtail the ability of individual district judges to issue nationwide blocks on executive action. And Judge Boasberg is not backing down. Within minutes of the administration's refusal becoming public, he issued a sharply worded 3-page order demanding immediate compliance with his earlier directive. The government now has 72 hours to produce a detailed plan showing how the deported Venezuelans can meaningfully contest their removal. The order ends with a clear warning. Failure to comply will result in the court initiating contempt proceedings sua sponte, including monetary sanctions, coercive incarceration of responsible officials, and referrals for disciplinary action. Legal analysts recognize the language instantly. This is the nuclear option. The Justice Department had already branded Boasberg's ruling an unconstitutional intrusion into presidential authority. But the judge's response reframed the dispute in stark terms. Obey a lawful court order, or face consequences. Behind closed doors at the Department of Justice, anxiety is reportedly spreading. Career attorneys now find themselves defending outright defiance, a position many believe is legally unsustainable. Several mid-level officials have quietly requested reassignment. It's the classic institutional signal of fracture. Stephen Miller, appearing on a friendly podcast just hours after the order dropped, doubled down. No unelected district judge gets to dictate how the commander-in-chief protects American citizens, he said. We will not bend. That soundbite is already looping across conservative media, but contempt mechanics are unforgiving. If the 72-hour deadline passes without compliance, and insiders concede privately that no such plan exists, Boasberg can summon senior officials, including Attorney General Pam Bondi and DHS leadership, to testify under oath. Non-appearance escalates sanctions. Daily fines accumulate. Asset freezes become possible. In the most dramatic scenario, bench warrants could be issued. One veteran D.C. litigator described it bluntly. Once contempt is certified, pressure becomes real before appeals even land. The administration's strategy hinges on speed. Late tonight, the Solicitor General's office filed an emergency application for a stay, bypassing the D.C. Circuit entirely and going straight to the Supreme Court. The move is extraordinarily aggressive. The 68-page filing argues that the president cannot fulfill his constitutional duty if a single district judge can indefinitely halt enforcement through open-ended procedural demands. It asks the court to block the compliance order immediately and halt any contempt proceedings. The application landed on Justice Court Kavanaugh's desk, the circuit justice for the D.C. Circuit, late enough to force rapid circulation among all 9 justices. If 4 grant the stay, lower court pressure evaporates overnight. If they don't, the administration faces real consequences next week. Behind the scenes, former Trump-era legal heavyweights are being mobilized. Progressive groups are racing to file opposition briefs, warning of dangerous precedents reminiscent of wartime internment. President Trump has already weighed in, calling Boasberg a radical judge and accusing courts of trying to steal the election's mandate. Millions have seen the post. International reactions are cautious but uneasy. Financial markets remain volatile. This is no longer about one deportation flight. It is a test of whether the American system can function when an executive branch declares a court order unenforceable, and whether courts have the means to respond. 3 paths now lie ahead. First, enforcement. The Supreme Court intervenes, grants the stay, and signals limits on district court power. Trump's agenda accelerates. Second, collapse. The stay is denied. Contempt proceedings begin. The administration either retreats or escalates into open constitutional conflict. Third, historic confrontation. Litigation drags on for months, spilling into the 2026 midterms. turning executive versus judicial power into a national referendum. Whatever happens, nothing returns to normal. The precedent being set, that defiance can succeed if backed by a favorable court, will reshape governance for decades. And as institutions move faster, quieter, and more aggressively, one truth is already clear. This is the point where containment ends and raw power takes over.